In this video, we're going to focus on the final three things that you have to have an appreciation of to understand how a contract comes into formation. The first of those is an intention to create legal relations. We already talked about this briefly when we were discussing an offer, but we're going to discuss it in more depth now, and we're going to focus on the difference between a domestic relationship and a domestic agreement and a commercial agreement to see how the presumption changes between those two arrangements. We're then going to focus on capacity to give us an idea and an understanding of who can actually enter into a legally enforceable contract. What happens if the person making the offer is intoxicated or mentally incapacitated and so on. And then the final thing we're going to look at is consideration and the legal concept of that exchange of something of value which makes the promise binding and separates it from the more non-binding gratuitous promise. What we're going to look at with respect to consideration are the rules that govern it. And there are a few of them, and there's a few exceptions to the rules as well, which we will go on and explain in quite a bit of detail. We start this video by looking at the notion of consideration, which, as we've said previously, is that exchange of something of value between the parties. So if I make a promise to you, you must give me something of value in consideration of my promise. And that's where the word comes from. If you don't give me something of value in consideration of my promise, then my promise cannot be enforced. You have to give something in order to enforce a promise. And that something is consideration. And that's what we consider under our first topic. The other thing that you must have to have a legally enforceable contract is an intention to create legal relations. You can have an offer made, you can have an acceptance of that offer forming the agreement, you can have the sufficient consideration exchanged, but if the parties didn't intend a legally enforceable contract to arise, then it cannot be enforced upon them. There has to be an intention there to enter into a binding agreement. And then the final thing we look at is capacity. We'll look at the difference between minors and people with a mental incapacity, and then people who are intoxicated as well, to see what the law says when it comes to entering into contracts and people who perhaps could be precluded from entering into contracts. Starting then, as we always do, with a bit of perspective. We've already talked about the agreement, the offer and the acceptance. We're now talking about the things that must go with that agreement to make it enforceable. That agreement has to have an intention behind it to create legal relations, and as part of that agreement, consideration must be given, consideration must be exchanged. Otherwise, the agreement will not be enforceable. So you need all three of these things for a valid contract to arise. Breaking down consideration then into its bare bones, we're going to start by looking at the definition, and that is traditionally done by looking at two separate cases. First of all, Curry and Misa, which is the older of the two, and then moving forward into Dunlop and Selfridge. And we're going to look at what the judges had to say about the concept of consideration in those two particular cases. Unfortunately, I don't think it's a particularly easy thing to extract from those judgments. It takes an awful lot of thinking, and just because of the archaic language that is used, but I've got a little animation that goes with Dunlop and Selfridge that will hopefully convey that in a very useful way. We will then go on to look at the various rules that govern consideration, namely that it must move from the promisee. So me as the promisor, if I promise you something to sell my car for £1,000, you as the promisee must give me that £1,000. That £1,000 is the consideration that we are talking about. So it must move from the promisee. We'll also look at the other rules, that it must not be passed and that it must be sufficient but need not be adequate. We'll talk about the peppercorn rent in that regard. And then finally, we will look at existing duty scenarios. And when does the performance of an existing duty, so that could be by contract or that could be via a public duty, when does performance of that existing duty arise to fresh consideration to enforce a separate promise? And we'll look at a couple of the general rules in that regard and then exceptions to those general rules. I always start with this slide then and just asking that question, what actually is consideration? Because I don't think the word consideration itself really gives much away. So the way to think about it is, if I want to enforce someone's promise, I have to have given something in consideration of that promise. If I want to enforce a promise that you make to me, I have to have given you something in consideration for that promise. So that's where the turn of phrase comes from. If I make a promise and I don't get anything in exchange for it, then my promise will not be enforceable. That promise will be what's known as a nudum pactum, which is the Latin phrase which essentially boils down to a naked nudum promise, a naked promise or a bare promise, which is not legally enforceable. So if I promise to sell you my house and you just say okay and don't give me anything in return for it, my promise to sell the house is a nudum pactum and it is simply not enforceable. If you give me a penny in return for it, it would, and we'll look at why that is the case when we look at the rules of consideration a little bit later on. Before we move on to look at the rules of consideration then, it's just worth noting that the concept itself is actually shrouded in quite a lot of academic debate. You would ask yourself the question, if the parties made a promise to one another and they intended those promises to be binding, then why does something of value have to be exchanged? Again, we will look later at the rule that consideration has to be sufficient but not adequate. So why does exchanging something for a penny suddenly make it legally binding? And that's the view that's held in many other legal jurisdictions where they don't have a requirement for legal consideration to be exchanged. I'll let you go and look at the position under Scots law, for example. So it is very much an arbitrary rule, but under the orthodox view in English law, it is still held as an essential ingredient to contract formation. So you must have it when you're dealing with contracts in England and Wales. Looking then at the legal definition of what amounts to a valuable consideration. So the starting point for this is always to consider the case of Curry and Misa back in 1875. This particular definition will always send shudders through law students everywhere because it's quite a difficult one to get into your memory to be able to recite it in an exam. So it's on the screen there and it's a valuable consideration, and it talks about it in the sense of a benefit and a detriment. So a benefit to one party. So if I make a promise to sell you my car for £1,000, I get the benefit of that £1,000. So that's the benefit coming to me as the promisor, moving from you, the promisee. And the detriment is suffered by the other party. So it would be suffered by you in that scenario by handing over the £1,000 as the promisee. So there's a benefit and there's a detriment. And by looking at consideration in that way, it can be quite easy to spot. So the definition itself from Curry and Misa, I have broken it down and I have highlighted it here just to analyse where the benefit words come from and where the detriment words come from. So the judge in this case set out that the benefit could be any right, interest, profit or benefit accrued to one party. So using our example, that was the £1,000 that I got for the car. And the detriment words can be some forbearance, some detriment, loss or responsibility given, suffered or undertaken by the other. So in our example, that was you handing over the £1,000. So again, that is how the courts used to look at it, by considering the benefit on the one hand and the detriment on the other hand, but now they do something slightly different, and that will take us on to the case of Dunlop and Selfridge. So with Dunlop and Selfridge then, we have another particularly difficult definition to examine. The definition here comes from an academic named Pollock, and it was used in the case of Dunlop and Selfridge. And that is what we can see on the screen there, that a consideration is an act of forbearance or the promise thereof, and that is the price for which the promise of the other is bought, and the promise thus given is enforceable. So what that breaks down to, if I am the promisor, so the person making the promise, and I promise to sell you my car for £1,000, you have to, as the promisee, give me some act of forbearance, give me something in return for that promise, or promise to do so, promise to give me money for it. So that's what that definition breaks down to. So to help us with that, I've got a bit of an animation. So we've got two average Joes, and on the left hand side we've got the promisor. So I'll sell you my car for £1,000. He stole my example there. So that is the promise to sell. And throughout the remainder of this video, we're going to look at those promises, and they're going to be all highlighted in green. So we're going to have a bit of a theme here. Anything that you see in green is the promise that we're trying to have made enforceable by giving consideration in return for it. So if the promisor makes that promise, the promisee has to give consideration in return for it. So using our Pollock definition from Dunlop and Selfridge, that is the £1,000. That is an act of forbearance, or they could promise to give £1,000. That is also good consideration. So that is the act of forbearance as described in Pollock. So if that £1,000 has been given, or the promise thereof, then the promise to sell the car, shown in green, will be enforceable. So hopefully that starts to all make sense when you break it down and use it in that diagram format. So now that we are all dead comfortable with the definition of consideration and we understand what it is conceptually, we're now going to look at the rules and the legal rules that govern it. The first of which is that it has to move from the promisee. So in our last example, I was the promisor and I promised to sell my car for £1,000. The consideration is the £1,000 and it moves from the promisee, the person to which my promise was addressed. The other rule is that consideration must be sufficient, but it need not be adequate. So the law doesn't care how good the deal was. They don't care if the £1,000 was enough for that car. All that they care about is that something of value was exchanged. We don't have to exchange a fair value. So that's what that is all about. It has to be sufficient, it has to be something of value, but it need not be adequate, it need not be enough. The final one then is that consideration must not be passed, and we're going to use a few examples to exemplify exactly what we mean by that. Number 4 on the screen there isn't strictly a rule that governs consideration standalone, but we're going to look at a couple of existing duty scenarios. And what we're looking at there is when a party is already contractually bound to do something, or bound by law, or imposed by a public sector duty, or if they already owed a duty to someone else under another contract, when will that duty be good consideration for a new contract? So that's what we mean by that fourth category when we look at existing duty scenarios. Our first rule then is that consideration must move from the promisee. So we've already touched on this rule a couple of times previously, that if I make you a promise and you want that promise to be legally enforceable, you have to give something in return for it. You have to give something as the promisee in consideration for my promise. Otherwise, it will not be binding. The case that we have for that is Dunlop and Selfridge, which we've already talked about, but we also have Tweddle and Atkinson, which was a case to do with a couple getting married and their fathers came to an agreement between themselves. So the two fathers came to an agreement that they would pay the groom a certain amount of money. Problem was, both fathers passed away and the groom tried to sue their estates to recover that money. But what the court held in that particular case, you didn't give anything in consideration for that promise, Mr. Groom. Because you didn't give anything in consideration for it as the promisee, despite the fact they promised you the money, there's no contract there. The promisee has to give consideration to enforce a promise against them. And that is the point from both Dunlop and Selfridge and Tweddle and Atkinson. So we've got here, just again, the same slide that we had previously with our promisor and our promisee, using the same example that we've already discussed. That if I promise to sell my car to you, so I'm the promisor, that's the promise that we're trying to enforce here, and you say, that's fine, I'll give you £2,000 for that, you have given consideration as the promisee, and my promise will thus be enforceable. Again, using that definition from Dunlop and Selfridge. So hopefully that slide makes a lot of sense, and hopefully it makes sense when you look at it in that diagram format as we've used previously. The second rule then is very important, and that's that consideration must be sufficient, but it need not be adequate. What we mean by sufficient, we just mean something of value being exchanged. The courts do not care whether or not that value, however, is enough to cover the promise in question. So if I promise to sell you my house and I get nothing in return for it, there's no consideration there. It is not sufficient to do nothing. But if you promise me a penny in return for it, that is sufficient because you're giving me something of value, but the fact that it's not adequate is completely irrelevant. The fact that my house is worth 200,000 or whatever is completely irrelevant. The fact that you've given me a penny is all that we need. It is sufficient, and it doesn't matter as to whether it is adequate or not. That principle all stems from the doctrine of freedom of contract. It is not for the courts to intervene to separate the parties away from a bad deal. That is not their function, that is not their role. They're just there to make sure that those constituent elements are present, so the agreement, the intention and the consideration, and if all of that is there, there is a legally enforceable contract, and that's all they care about. The case that we have for that is Chapel and Nestle, very interesting case. Nestle being the chocolate people. They ran a promotion in the 1950s for the sale of gramophone records, and they promised to give people gramophone records if they gave them a certain amount of Nestle chocolate wrappers in return. And the question was those chocolate wrappers, was that valid consideration to allow a contract to be formed? And the answer to that was yes. The courts held that to Nestle, getting the chocolate wrappers was valid consideration. They got a value from that, and the value that they got was not the chocolate wrapper, because they destroyed that afterwards. The value that they got was the increase in chocolate sales. So again, they got some sort of value from requesting those chocolate wrappers. So a very useful case to exemplify that particular point. Going back to our brunette gentleman then, looking at our promisor, we've got a promise to sell the car for £1. So hopefully everybody's taken away from that that £1 is sufficient. The fact that it's not adequate doesn't matter, and we would have a valid and enforceable contract on that particular circumstance. Our next scenario is where the promisor promises to swap the car for a pen. So I'll give you my car, I'll sell it to you for a pen. So the person and the promisee gives the pen, and the question is that sufficient? And the answer would be yes. That pen is something of value. The fact that it is not monetary doesn't matter in the slightest. The consideration is there. It is something of value being exchanged. Its adequacy is completely immaterial, and a valid contract will be formed on those facts. And our final example then is if our promisor promises to give away the car for free. So they're not asking for anything in return. And what we call that is a nudum pactum. That is a bare promise, a naked promise, which would ultimately not be enforceable. It is completely gratuitous. So therefore, Mr. Promisee, they could not take the promisor to court and enforce that contract because they did not give anything in consideration in return for it. The promisee didn't give consideration for the promise, and therefore the promisee cannot enforce it. Our third rule then is that consideration must not be passed. It has to be given in return for a promise. It has to be given in return for the promise that you're seeking to enforce. So, for example, if I offer to sell my horse to you for £1,000, you accept the offer and you give me the £1,000. So we've got the offer and the acceptance, and we've got the £1,000 as our consideration. So we've got a valid contract there, which has been formed. If I then make another promise after the sale, for example, that the horse is sound and free from vice, that's a fresh promise. And to make that promise enforceable, fresh consideration must be given for it. If no fresh consideration is given, then there is no valid contract, and that extra promise cannot be enforced because, again, there's nothing has been given in return for it. The consideration that was already given, the £1,000 for the horse, that's in the past. That's a completely separate deal, and it's a completely separate contract. What we're dealing with here is a new promise, and where there's a new promise, you need fresh consideration. So that's what that is all about. And that particular set of facts about a promise being made about a horse after the fact, that it is sound and free from vice, is the facts from Russ, Corlett and Thomas, and that is the case that we use for this particular point. What happens, however, when we've got a scenario that is a little bit more like this? So I've got a window cleaner, and they come up to me and they say, I cleaned your windows last week, William. And I say, okay, right, fair enough. I promise to pay you for that whenever I have cash available. Happens all the time. You don't have cash, you promise to pay them at a later date. So our general rule is that consideration must not be passed. So the question then looms, well, what consideration has been given for that promise to pay? And the answer is the windows being cleaned. But the windows being cleaned, that's something of value being given in return for that promise, happened in the past. So what we're about to look at here is an exception to the general rule that consideration must not be passed. You can probably imagine in that scenario that there would be good utility in having a way to enforce that promise to pay. And there is exactly that, and we're now going to look at the PA1 exception to the general rule. The exception then to the general rule that consideration must not be passed comes from the Privy Council decision in PA1 and Lao Yu Long. Again, I'm probably pronouncing that terribly, but the test is quite straightforward. So the test is threefold, and all three of these limbs have to be satisfied for the exception to come into play. The first limb of the test then is that the act must have been done at the promisor's request. So, using our window washing example to try and understand this, were the windows washed at William's request? Again, lots of W's in that sentence. Were the windows washed at William's request? And assuming that the answer to that is yes, you then move on to the next limb of the test. You can imagine scenarios where that would not be the case. You drive up to a red light and someone starts washing your windows. You didn't invite them to do that. So therefore, the fact that they have done it, you don't have to pay them for it. The fact that they've done it in expectation of you paying them is not enough. It has to have been done at the promisor's request. The second limb of the test is that the parties must have understood that the act was to be rewarded. Would the reasonable person observing this scenario have thought that payment was to be exchanged? So in our particular example, did the parties expect the windows to be paid for or the window washing to be paid for? So assuming that that is yes, then you move on to the third and final limb. And again, in a commercial context, why else would someone be washing windows if there was no expectation of payment? So taking into account that circumstance, in our example, that box is ticked off. The third and final requirement is a bit of a tick box exercise, and that is, would payment have been legally enforceable had the contract been formed in advance? And the answer to that on our particular facts, is it legal to wash windows? Is it an enforceable contract? Yes, it is. So in our particular set of circumstances and the window washing example, there is a valid exception to the rule that consideration must not be passed. This PA1 exception is a very important one, and it's quite an easy thing for examiners to spring into the facts of an exam or into a piece of coursework. So always bear this exception in mind. We're now about to consider the existing duty scenarios, and when will performing an existing duty amount to good consideration? We're going to look at existing duties under contracts, existing duties under law or under statute, and then existing duties owed to third parties. So we'll look at all three of those separately, starting with existing obligations within a contract. So the scenario is this: if I am a ship's captain and you are a shipmate or a sailor, we're in contract and your obligation is to sail that ship home. If, for whatever reason, and we'll look at this in detail, I, as the ship's captain, promise you more money just to get the ship home, just to perform your existing obligation, the question is, when will that promise be enforceable? When will your mere performance of your existing obligation amount to fresh consideration to make that new promise enforceable? So that's what we're looking at here. So the question that you have to ask yourself to answer that question is, has the party seeking to enforce the promise, so the sailor in this scenario, have they done more than they were already bound to do by the existing contract? So that's the question that you have to remember, and the question that you have to ask yourself when dealing with this existing duty scenario. If the answer to that question is no, you haven't done anything extra, then there is no consideration, and the promise in our little example to pay you more is unenforceable. Okay, and the case that we have for that is Stilk and Myrick, again a very famous case, and we will look at the facts of it shortly. If the answer to that question is yes, and you have went above and beyond your original contract obligations, then that will be good consideration, and in our example, the promise to pay more would be enforceable. And the case we have for that is Hartley and Ponsonby, which again we will look at shortly, because the facts of it are very similar to Stilk and Myrick, and you can easily distinguish the difference between the two outcomes in those cases. So we're about to look at the two contrasting cases of Stilk and Myrick and Hartley and Ponsonby. People always compare and contrast these cases because it perfectly illustrates the difference between what is valid consideration and what is not, and when the mere performance of an existing obligation will amount to consideration. Starting then with Stilk and Myrick. So in this case we have a sailing ship. It's sailed out to the Baltic Sea, made land, and then 2 of the 12 sailors deserted. To get the ship home, the captain made a promise, and he made a promise to pay them more money. So that is the promise that we're going to be talking about here, and whether or not that promise is enforceable. So what we've talked about previously, for a promise to be enforceable, consideration has to be given in return for it. So the question is doing a little bit of extra work good consideration, or is it not? So you can ultimately imagine where this went. The captain decided to not pay them. He refused and reneged upon his promise, and the sailors sued him for that. The courts found in this particular set of facts that the sailors did not give any fresh consideration. They did not give fresh consideration because they were always contractually bound to get that ship home. Merely having to do a little bit of extra work did not go above and beyond their original obligations, and ultimately the courts held that that promise was unenforceable. No contract formed on the foot of it for want of fresh consideration. We will now consider the case of Hartley and Ponsonby. Very similar facts, all to do with a sailing ship. But when this particular ship made land, 17 of the 36 crew members deserted. The difference here is that that's closer to half of the crew as opposed to a mere 1/6 in Stilk and Myrick. So again, very different in terms of that one particular fact pattern. Very similar thing happened. The captain promised them more money to get the ship home, and ultimately he refused to pay that whenever they got back to the UK. In this particular circumstance, however, the court held that the promise to pay more money was enforceable. It was enforceable because the shipmates went above and beyond their existing obligation. They did something that they hadn't signed up to. They were effectively doing twice as much work. So therefore, that was the consideration that they gave in return for that promise of more money. Consideration plus that promise made that promise binding. And that's what this case is all about. And that's why people often compare and contrast the cases of Stilk and Myrick. We're now about to consider an exception to that general rule that merely performing a contractual obligation doesn't amount to new consideration. And that exception is set out in the case of Williams and Raffi brothers. So what this ultimately boils down to, a subcontractor was running late and a main contractor promised to pay them more money if they just finished on time. If they just completed as per their original contract, they will get more money. And that is the case of Williams and Raffi, and we'll look at its facts now. In terms of the facts of Williams and Raffi then, we have Winhome Mansions at the top of the tree. They are the employer, and beneath that we have the Raffi brothers, who are a main contractor. So between the employer and the main contractor, we've got the main contract, and as part of that main contract, there were liquidated and ascertained damages, or LADs as we call them in the construction industry. It's just an agreed form of damages, a certain amount of money per week or per day, or whatever way they have worked it out. We will talk about agreed damages clauses later, and we'll look at the case of Cavendish Square Holdings for that, but that's in a later video. So beneath the main contractor, we had the subcontractor, and that was Williams in this particular circumstance. It was a 20 grand subcontract for some joinery and carpentry work. So the problem was Williams started to fall behind on programme. They had dramatically underpriced the work, and as a result of that, they fell behind and were underperforming. To try and rectify that poor performance, Raffi brothers, who were the main contractor, promised to pay them £10,300 extra. That promise was just for them to do what they had already signed up to do, to meet a certain deadline. So they were promising them more money for Williams just to perform their existing obligations. And that's the key here. And we'll examine why this is a little bit strange and sits slightly ajar to the principle that we just looked at in Stilk and Myrick shortly. So the point is, by making that promise to pay them more, the Raffi brothers were able to get a benefit from that. Or put another way, they were able to avoid a disbenefit, and that's what this ultimately turned on. The disbenefit that they avoided was having to bring in another subcontractor, having to make Williams go insolvent, to retender their package and to bring in someone else. That takes an awful lot of time, and ultimately that's going to cause a lot of disruption as well. The other thing that they avoided was the liquidated damages provision being applied to them within the main contract. So if they had finished late as a result of Williams, Raffi brothers would have been hit with those liquidated damages. They don't apply directly to Williams from the employer, they are hit to the main contractor. So by paying and promising to pay Williams a little bit more, they were ultimately able to avoid these disbenefits. And that is the consideration that this case ultimately turns on. And we're going to now examine what the judge and what Lord Glidewell had to say about this particular circumstance in his judgment. Looking then at the decision of Lord Justice Glidewell in Williams and Raffi brothers. But before we do, let's just remind ourselves of what Stilk and Myrick was all about. So the ratio of that case, the ratio decidendi, the reason for the decision, was if you are merely performing an existing obligation under a contract, that is not good consideration. If the ship's captain promises to pay you more money for merely doing your job, that will not be enforceable because you were merely doing your job under the contract. So that's what Stilk and Myrick is all about. However, that principle has now been limited slightly and qualified by the decision in Williams and Raffi brothers, by the decision of Lord Justice Glidewell specifically and his 5-part test. What I would invite you to do just now is to pause the video and to read these 5 bullet points in detail. Read each one, understand it before you go on to the next one. If you do that, it will all start to make sense. So assuming that you've paused the video and that you now understand it, I'm going to read through it, but I'm going to read through it in such a way that I'm reciting the facts of the Williams and Raffi brothers case, just to bring all of this home and to help it make sense. So A has entered into a contract with B. So in our circumstance, Raffi brothers has entered into a contract with Williams, the subcontractor. Ticked off. Part 2. At some point, the Raffi brothers had reason to believe that Williams was not going to perform their side of the bargain. So on the facts, that was a given. It was a subcontract package and they were clearly falling behind. The works were not being erected as per the programme. Part 3 then. Because of that doubt, because the fact that Raffi saw the subcontract works were lagging behind, they promised to pay Williams more money if they would simply hurry up. I'm going to pay you £10,300 extra if you just complete by the agreed date. So they were offering to pay more money to try and alleviate that problem. And that takes us on to point 4. As a result of making that promise, the Raffi brothers obtained a benefit. Moreover, they avoided a disbenefit. They avoided having to pay out the liquidated damages to their employer. They avoided having to bring in a new subcontractor who would charge them more money to do the work ultimately. That happens in construction. When you bring in a new subcontractor to replace an old one, there's usually an uplift because they have to take the risk of all of that work that was already installed and working over the top of others. So again, they avoided having that disbenefit by simply paying the Raffi or simply paying Williams a little bit more money. And then the 5th one is an important one, that promise by Raffi brothers to pay more money was not given under economic duress. It was not the case that Williams simply sat back, rather candidly, twisting their whisker sort of thing, saying if we go slow enough, they're eventually going to have to pay us more money. It was not the case. It was a genuine instance where they had underpriced the work and Raffi had ultimately attempted to renegotiate that with them. There was no sense of economic duress there, and therefore all 5 parts of this test were ticked off. Where that ultimately takes us is an exception to the rule in Stilken-Myrick, that if all 5 of these limbs are ticked off, the mere performance of an existing obligation can amount to fresh consideration, and the promise that was made by the Raffi brothers in this case was enforceable, because the consideration that was given in return for it was them avoiding that disbenefit, along with all of the other factors you see on screen. Our second category of existing duty scenario is duties imposed by law or duties imposed by statute, and we call those the public duties. So the general rule is that comes from Collins and Godefroy is that merely carrying out a public duty does not amount to fresh consideration. So if I promise a police officer £10 to stop that criminal, they were already bound to stop that criminal anyway, so therefore my promise is not enforceable. So that's what this is all about. The case that we use for that is Collins and Godefroy, which is a case to do with a man being subpoenaed by the court. So in this particular case, Collins had been promised by Godefroy 1 guinea per day to act as an expert witness, but he was already subpoenaed by the court anyway, and because he was subpoenaed, he was under an obligation at law to turn up. So because he was already required to be there, the promise for him to be paid was not enforceable. So that's what Collins and Godefroy is all about. The next case that we have there is England and Davidson. Again, a case to do with a police officer who was trying to claim a reward for coming forward with information. It was held in that case that the duty of a police officer is to enforce the law, but going above and beyond by providing that extra information was valid consideration on that particular set of facts. I would invite everybody to look up that particular case, as it is an interesting one and a particularly useful one. Harris and Sheffield United is another case to do with the police, and another case where the police went above and beyond what their statutory requirements were and what they were required to do as their existing public duty. And then finally, Ward and Bytham is a very interesting case to do with the upbringing of a child. I will let everybody go away and do their own research on that one, as it's very, very bizarre. And again, the court used a very bizarre logic to hold that there was valid consideration in that particular case. So I would invite you to read the judgment of that one very, very carefully, and to perhaps look at some of the academic criticism of that case to help you understand when a valid consideration will arise by merely performing an existing public duty, such as bringing up a child. Our third and final category of existing duty scenario is an existing duty owed to a third party. And the case that we have for that is Scotson and Pegg. It's a rather complicated one, so we've got a useful little diagram about to appear for that. But the general rule is that we derive from this case is that performing an existing obligation to a third party can amount to valid consideration, and it can be good consideration. So that's the key takeaway here. It's a very old principle, all the way back from 1861, but it was approved more recently by the Privy Council in that PA1 case that we looked at previously. We looked at it in the context of it being an exception to the general rule that consideration must not be passed. But moving on now to Scotson and Pegg. So the facts of this case are as follows. We have Scotson, and they had a contract to supply coal to some third party. Again, it's not Scotson or Pegg, it's someone else here. They're the third party that we're discussing. That third party also had another contract, and they had a contract with Pegg to sell on the coal to them. So again, you can see how this relationship ultimately arose. One party gets the coal, delivers it to another, and they sell it on to another. So Scotson, the third party, and Pegg. We then had this obligation on Scotson. So as part of Scotson's contract with this third party, they were required to deliver the coal straight on to Pegg. So again, instead of giving it to the third party, they were just required as part of that contract to deliver it straight on to its end user, who was Pegg. So that's the existing duty that we're describing here. What happened ultimately was a promise which was made from Pegg for Scotson to offload the coal at a certain rate. So whenever Scotson turned up to Pegg's yard, Pegg made a promise to them that they would pay them to offload the coal. So that's the promise that we're describing here, shown in green. Ultimately, Scotson turned up, offloaded the coal, and Peg refused to pay for that. And this is where it ultimately ended up in court. Peg tried to argue, why should I have to pay out that money that I promised? Because they were already contractually obliged to do it anyway. And the point is that particular promise was enforceable, because the general rule that we've established in this case and what the court arrived at is that performing an obligation to a third party is good consideration. This is different to Stilk and Myrick, where the existing obligation would have been between Scotson and Peg. This is an existing obligation and a duty owed to a third party. Peg was getting a benefit, and ultimately that was good consideration. So that is us the whole way through consideration. Hopefully everybody is starting to understand what consideration is, that thing that is given in return for a promise to make the promise enforceable. We're now about to look at the third and final requirement that is needed to form a legally enforceable contract, and that is an intention to create legal relations. I personally think that this is quite an easy topic. It really does, what it says on the tin. If you don't have an intention to create a contract, then the contract will not come into existence. It's much more straightforward than consideration, which is much more of an abstract topic, talking about something of value, but intention is a lot more tangible, and it's something that you can really understand by just looking at the word. So the point is, if there's no intention to create a contract, then no contract will exist. The case that people often cite for that particular principle is Rose and Frank and the Compton brothers. It was a case to do with the sale of tissue paper, hence the little diagram that we have on the screen, and they expressly wrote into that contract that notwithstanding any other provision of this agreement, we do not intend this agreement to be binding. Okay, so they had wrote out that they do not want this contract to be binding upon them. And that's a perfectly valid thing to do, and it showed that they had no intention to create a legally binding contract. And a key extract from that particular case is what the judge said: to create a contract, there must be a common intention of the parties to enter into legal obligations, mutually communicated, expressly or impliedly. So that test of whether or not there is an intention there between the parties is an objective one. So what would the reasonable man or woman think the parties intended? If it's a commercial relationship, business to business, the reasonable person would generally think that they did intend to create a contract. And that's exactly what we will look at first of all, what that presumption is when it comes to commercial agreements, that rebuttable presumptions, because it can be rebutted, as it well was in Rose and Frank and Compton brothers. That was a commercial relationship to do with the sale of tissue paper, but they had wrote into the contract that they didn't want it to be binding, so that presumption was rebutted. The other presumption that we look at then is in the social or domestic arrangement, and the presumption in that scenario is that there is no intention to create a contract. So if a husband and a wife come up with an agreement as to washing the dishes or mowing the lawn or whatever it may be, do you think that they intended that agreement to be legally binding? If one didn't mow the lawn and the other didn't do the dishes, that they could sue each other for that, for damages or specific performance? Very unlikely. So those are the two things that we're about to look at now with respect to intention. Looking then at the business arrangement first of all, or the commercial arrangement. So the point is there's a rebuttable presumption that people dealing business to business intend to enter into contracts, and that is a very strong presumption. The case that we have for that is Rose and Frank and the Compton brothers. That's also the case that sets out that that presumption can be rebutted. So as we said previously, in that particular case, the parties in the commercial agreement had a provision within it that set out expressly that we do not intend this agreement to be legally binding. So there was a offer and the acceptance, which formed the agreement. There was consideration exchanged, the tissue paper for the money, but there was no intention there. The agreement was formed, but on the basis that it would not be legally enforceable. That's a very odd thing in a commercial agreement, because the whole reason that you enter into a contract is to make sure that those promises are binding, which is why that presumption is so strong, but ultimately it can be rebutted. As we said previously, the test for what amounts to intention is an objective one. So would the man at the back of the Clapham omnibus, reasonably cognizant of all the facts, what would they have understood the intention to be? Did they think that those parties would have intended to create an agreement? So that's the test here. And when it comes to a commercial environment, that answer is probably yes. There's one main exception to that rule, however, and that is mere puffs. And the example that we use for that is the likes of Weeks and Tybald, probably one of the oldest cases that we are going to study. And that case was to do with Mr. Tybald making a very bold promise of £100, which back in 1604, according to my inflation calculator, was about £30,000 in today's change. He promised £100 for anyone who would come forward and marry his daughter. Mr. Weeks did just that, married the daughter and tried to claim the £100 off Mr. Tybald. He said that I accepted that offer and we're in contract, and if you don't pay me, that's breach of contract and I can sue you for it. The court threw out that position and basically said there was no intention there for him to create a contract. It was simple, mere puff. It was mere puffery and there was no intention behind it for it to be binding. On the opposite side of the spectrum then, we have social and domestic agreements or social and domestic arrangements. And the presumption in that scenario is that there is no intention to create a legally enforceable contract. That said, that presumption is also rebuttable. So depending on the facts and the circumstances, you could rebut that presumption. So if a husband and a wife had, entered into a formal written contract and they had expressly set out that they want it to be legally binding, then that presumption would be rebutted at that point and there would be a valid contract there. But assuming that that's not the case, the presumption is that in this scenario, there is no intention to create a legally enforceable contract. And we've got a few cases just to exemplify that point. So between husbands and wives, we have Balfour and Balfour, which was a case to do with a happily married couple at one point. The husband went away to work overseas and he promised to pay the wife, a housekeeping or an allowance every month. The relationship ultimately broke down and she tried to sue him whenever he stopped paying. But the court held that that was a purely domestic relationship or a purely domestic contract and therefore it was not enforceable. Very similar circumstance in parents and children. We've got the case for Jones and Patavatin for that. So the daughter lived in the US and she moved to the United Kingdom under the influence of the mother, and the mother promised to pay for her accommodation. The relationship broke down, one of them sued the other, but the courts held that there was no valid contract in place because that was a purely domestic relationship. Even though it was to do with money, changing hands, they still held that in those circumstances, it was merely domestic. That can be contrasted, however, to the final case that we have there, which was between housemates. And again, this will very much depend on the facts, but in that particular case, Miss Simpkins was a lodger and she was lodging or boarding at a B&B of Mrs. Pays, who also lived with her granddaughter, also called Mrs. Pays. The three of them entered into an agreement, which is the problem here, to run a raffle every week or enter into a newspaper competition every week. And the agreement was that they would take a turnabout and in the event that they won something, they would split the prize between themselves. So the week in question, Mrs. Pays, the grandmother, it was all in her name, and funny enough, she won. And what did she do? She refused to pay out to Miss Simpkins, and hence Miss Simpkins is the plaintiff in this case. So she sued Miss Pays for breach of that contract, that they would split the prize money. In that particular circumstance, the court held that there was an enforceable contract. The presumption was rebutted because Miss Simpkins was a third party here. She wasn't a family member, and despite the fact it was all very informal, that there was an intention there to create a contract. So that's a very important one to maybe contrast with the outcomes in Balfour and Balfour and Jones and Patavatin, because it was all to do with the certainty and the seriousness of the terms, which we have there in the final bullet point. So the key takeaway here is, in the first instance, the presumption in a social or domestic arrangement is that there's no intention, but it can be rebutted. And the opposite is true when it comes to commercial. There's a rebuttable presumption that there is an intention, but it can be rebutted that there's not. And we've got Rose and Frank and the Compton brothers for that. So that's it, folks. We've now dealt with both consideration and intention, and we've now got everything that we need to enter into a legally enforceable contract, but for one topic, and that is capacity. So what we're now about to talk about, again, is slightly different to contract formation. It's a slightly different topic in its own right, and that's what types of entity have the ability to actually enter into contractual agreements. And we're going to look at the difference between minors, people with a mental incapacity, and people who are simply intoxicated. And we'll look at what the law says with respect to that. So capacity then we will deal with rather swiftly. The key takeaway is that the rules with respect to capacity are there to protect the incapacitated party. They're there to protect the weak, and they're there to protect the less capable. So the examples that we use for that generally fall into three different categories. The first of which is minors, which is people under the age of 18. And the general rule for that is that they don't have capacity to enter into legally enforceable contracts. You can understand why. They're not deemed to have the level of knowledge and understanding to be able to bind themselves. They're protected by both statute, so there is a piece of statute law which is called the Minors Contracts Act of 1987, and it sets out what happens when a minor does enter into a contract, that it becomes voidable, so not void. It's not null and void, it is only voidable. So it could ultimately be affirmed if that individual, becomes 18, if they don't repudiate it by that point in time. But there's plenty of other rules that we'll not get into in any more detail. The next one then is mental incapacity, and it is also dealt with under statute under the Mental Capacity Act of 2005. Section 2 of that particular act goes into a bit of detail and sets out that someone will not have capacity if they're unable to make a decision for themselves due to an impairment. And it also goes in at section 3 to set out what amounts to an impairment, not being able to articulate or communicate what they're trying to say, or not being able to retain information, etc. So that one there is very much dealt with under statute via that Mental Capacity Act of 2005. The final one then is all to do with intoxication. We've got two very neat cases for that. So firstly, it will be up to the person trying to void the contract to prove that they were in fact intoxicated. And the case we have for that is Matthews and Baxter. So it's up to them to prove that. And they would also have to prove that the other side did not have knowledge of that. So if the other side was completely oblivious to this person being intoxicated, then the contract is valid. However, if you can prove that they were aware of the intoxication, then the contract becomes voidable. Again, we talked about voidable previously. The contract is not deleted at that point. It is ultimately up to the intoxicated person whether or not they want to void it. They can either choose to void it or to affirm it. Even though I was drunk and I made this very silly contract, I still want to be bound by it. I'm going to affirm it. But if the other party, assuming that you can prove that you were drunk, if you can prove that the other party was aware of your drunken state, then you could also void the contract and walk away from it, because it's there to protect people, from being taken advantage of in their drunken state.